The United States Supreme Court has handed down a massive, unanimous 9-0 ruling that fundamentally changes when law enforcement can march right through your front door without a warrant. If you think that your home is completely protected, you need to watch out because the Supreme Court delivered a massive warning for property owners nationwide. In a critical lawsuit, the Supreme Court was forced to confront a dangerous loophole regarding how lower courts evaluate emergency entries into your home. The state courts tried to create a loose framework that would have completely vaporized your privacy protections. The Supreme Court stepped in to issue a massive correction, but inside this unanimous ruling, there is in fact a hidden trap that everyday Americans need to be warned of. So we need to break down what exactly the Supreme Court did in this ruling and the alarming reality of how this impacts your rights immediately. Now, before we jump into what the Supreme Court just did in this ruling, if you like this type of content and you want to make sure that you get it going forward, make sure to like, comment, subscribe, and turn on all notifications to get updates on these videos when I release them. Now, to understand the impact of what just happened, we have to look at the unsettling facts that triggered this battle in the very first place. So this all started when police received a report regarding alleged threatening statements made by an individual named Trevor Case. That call was made to 911 by Trevor Case's ex-girlfriend, and when talking to police, she admitted that she could not remember exactly what he said, but she told the officers that she had a bad feeling and warned them that he could be dangerous. When 4 police officers arrived at his home, they knew Mr. Trevor Case, they had a history with him, they knew that he had a history of mental health issues. They looked through the windows, saw nobody inside, but noticed an empty holster and also a notepad. Now, here's where things kind of unraveled and where it created this case. The police did not immediately rush into the home. Instead, they stood outside of the house for over 40 minutes. Some of the officers openly stated that they did not think Trevor had it in him to do anything wrong, and they thought that nothing really was going on. But after 40 minutes, they discovered that the front door was completely unlocked, and they decided to go into the house without a warrant. Now, as officers searched the upstairs bedroom, one of the officers noticed that a closet curtain kind of suddenly jerked open. He saw what he believed was an individual in a black object, and so he panicked and then opened fire and essentially hit Trevor through the arm, which also went into his stomach. Now, after police detained Trevor Case, they did a search of the home and they recovered a weapon that was kind of close by in a laundry basket. Now, in response to this incident, he fought back in courts demanding that the warrantless evidence that was retrieved based on the warrantless entry into his home, that it needed to be suppressed under the 4th Amendment. This case eventually made its way all the way up to the Montana Supreme Court, who rejected Trevor Case's arguments in a 4-3 split decision. After that Montana Supreme Court ruling, Trevor Case then appealed and went up to the Supreme Court. Now, when the challenge reached the United States Supreme Court, it triggered a massive institutional clash. Mr. Case argued that the 4th Amendment requires strict probable cause before police can execute an emergency aid entry into the home, and he pointed out that the Supreme Court had already struck down broad community caretaking excuses in landmark cases like Caniglia versus Strom. But here is the wild part with this case. Both the state of Montana and the Trump administration stepped into this fight, actively arguing for a much lower standard of review. In fact, the Trump administration explicitly asked the Supreme Court to approve of a sliding scale, and this kind of sliding scale reasonable suspicion to give officers broad leeway into bypassing warrants to make these emergency entries to address emergency situations. Now, when the final decision dropped in this case, it was a total 9-0 shutout, and it went against that broad reasonable suspicion that was requested by the Trump administration and the state of Montana, but it also went against the very strict probable cause standard as well. The Supreme Court completely rejected the Trump administration and Montana's push for a loose reasonable suspicion framework, calling it way too weak to protect the home. But the justices also completely rejected Mr. Case's arguments, ruling that probable cause is strictly tied to criminal investigations and doesn't apply to life-saving interventions. Instead, the Supreme Court reaffirmed its prior standard in the Brigham City versus Stewart case, which essentially states that police do not need a warrant or probable cause if they have an objectively reasonable basis to believe that an occupant is seriously injured or facing imminent harm. Applying that standard to these exact facts, the Supreme Court ruled that because the officers heard a report that a weapon may have been involved, they saw an empty holster and got no response from someone who may be a harm to himself, they had an objectively reasonable basis to think that the homeowner might have harmed himself or was about to. So the Supreme Court emphasized that the Fourth Amendment does not require police to stand by and do nothing when a human life is at risk. The Supreme Court stated in the opinion that we repeat today what we have held before. An officer may enter a home without a warrant if he has an objectively reasonable basis to believe that an occupant is seriously injured or imminently threatened with such injury. The officer's entry satisfied that test according to the Supreme Court, and based on that, they said that they reaffirmed and affirmed the judgment below, even though they did not agree with the reasoning of what Montana actually said and what the state of Montana used to actually hold this ruling. So they agreed with the final judgment, they agreed with the outcome of the case, but not the rationale and the analysis. So in essence, the Supreme Court upheld the ultimate conclusion of the Montana Supreme Court, but rejected the analysis that they used to reach that conclusion. Reasonable suspicion was too loose of an analysis, and instead, the Supreme Court applies the objectively reasonable test. They also rejected Mr. Case's position that probable cause should in fact be the standard. The Supreme Court found that that test is too strong and would prevent police from performing necessary life-saving duties. So what is the ultimate conclusion here in this case? Well, the Supreme Court technically upheld the final judgment against Mr. Case, but they completely threw out and rejected the legal analysis that the Montana Supreme Court used to get there. While they stopped lower courts from expanding upon that loose, watered-down caretaking standard, they officially solidified a nationwide rule that is, if law enforcement can point to a credible report involving an objectively reasonable belief, they have the ultimate federally approved workaround to bypass your front door without a warrant and potentially confiscate property and do so potentially under the guise of an emergency. That is the hidden reality behind this unanimous 9-0 decision in the Case versus Montana. The loose standards were rejected, but the framework leaves a massive, unpredictable battlefield at your doorstep, and you have a lot of questions about, how loose could this actually be applied? There is no doubt going forward that there will be massive fallout from this ruling, and pending cases across the country will be impacted by that. So we're also going to be tracking that. So if you want to stay ahead of all of this and see how it plays out, make sure to hit the subscribe button, turn on all notifications to never miss these videos when I release them. Also, let me know in the comment section, do you agree with this 9-0 unanimous decision by the Supreme Court, or do you believe that this is too loose of a standard and violates fundamental constitutional rights? Let me know your thoughts down below in the comment section. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.